Good afternoon, you're all very welcome here today. My name is Professor Shane Darcy. I'm Director of the Irish Centre for Human Rights, and it's great to see so many of you here, colleagues, students, alumni, friends. Welcome and welcome back. The occasion today is the inaugural professorial lecture of our colleague, Professor Shane Darcy, on Ireland and the World, Appealing to International Law in Times of Conflict. This inaugural lecture has been delayed many times due to various circumstances, including, of course, the global pandemic of COVID-19, cyber attack on the university, and various other circumstances. So we're really delighted to be able to host this today at the start of a new academic year and as part of our opening week. And the inaugural lecture is an opportunity to celebrate an academic's appointment as professor. It's a celebration of the scholarly and wider academic achievements of a professor, and it's also an achievement that is the culmination of many hard years of work. It doesn't just happen. It comes with many years of work, much commitment, much dedication, and many sacrifices. So I'm very happy to welcome here also Shane's family, Anna Marie, Oisín and Killian here in the front row. It's also part of your celebration here today and part of your achievements. I know you've been accompanying this work, often maybe part of the sacrifices and times missed out while working on all of the scholarship that comes towards today. The inaugural lecture is also an opportunity to share this research and scholarship and years of teaching and human rights and international humanitarian law activism, to share with students, with colleagues, with wider communities and with the wider public. And that's a really important task for an academic, particularly for those working on and engaging in international law. And it's a reflection of the important role of the university as a place and a space for conversations, for informed debate and scholarship, research and teaching. And the lecture is taking place at a time of conflict, at a time when we continue to see deep inequalities, persistent systemic racism. It's more important than ever now that we draw upon international law, the resources of international law, its potential, unrealised, to build not just a rules-based order, but to try to contribute towards a global community premised on justice, equality and peace. And Shane's work and scholarship is internationally recognised as having made a really important contribution to international law across a range of fields. But underpinning this work is also a very deep commitment to the progressive development of international law. And I use that term progressive to mean in the pursuit of equality, in the pursuit of peace, in the pursuit of the promise of universal rights, protection and recognition, not realised, not achieved, but a pursuit and a premise that underpins Shane's work and scholarship, and also his commitment, his advocacy and activism for a better world. Shane's work spans the fields of international humanitarian law, international criminal law, business and human rights, public international law, and also increasingly historical research on tracking developments in international law, and today, of course, tracking Ireland's place. My colleague, Professor Ray Murphy, is going to introduce and speak more about Shane's work, but I just want to highlight in particular, as we celebrate this achievement and as we meet here today for this inaugural lecture, I also want to highlight Shane's collegiality, his generosity as a colleague, his care of students, many of you here today, and alumni, and those who've been in touch who couldn't attend but are joining us in spirit. Shane's constant generosity, both with his time and his expertise, his research and his scholarship, to wider civil society, to UN organisations, to international lawyers, to international organisations and human rights defenders. And often that is behind the scenes, not public, not visible, but a practice that we've seen in particular this year as we see the unfolding genocide in Gaza. Shane's work has been pivotal in supporting international lawyers, practitioners, UN entities, trying to achieve a more just world, trying to achieve a just and lasting peace and an end to the genocide. Shane is the director of our International Criminal Court Summer School that happens every year. And again, I just want to highlight that because it's not just a summer school, it's a globally recognised summer school that brings international lawyers, practitioners, scholars, students of international criminal law who are willing to give of their time very generously because of their connections to Shane's work, to Ray's work, to our colleague Professor Bill Shabas, and all of our students and alumni who work in the field of international criminal justice. And we are fortunate to be able to attract leading practitioners and scholars because they are willing to engage, because of Shane's commitment, and because of their respect for his work. He organises the annual field trip to The Hague, to international institutions, and again I highlight that because it's an incredible opportunity for students not just to visit the institutions, but because of Shane's connections, relationships, the respect for his scholarship and work, and recognition of his generosity and the time that he gives to others, that many doors are opened and there's a willingness to meet with our students, to engage, to support their work. And I think that's something that's also felt and recognised by alumni and is critically important. Shane's work on Palestine and in international law has been part of groundbreaking developments at the international level, including with the issuing of the International Court of Justice advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. He has been supporting the work of the legal team and lawyers engaged in the proceedings at the International Court of Justice in the case of South Africa and Israel. He's also been engaging with those who are working on the role and potential of the International Criminal Court. Shane has supervised students supporting the UN mandate of the Special Rapporteur on Human Rights in Palestine, and that work and the quality of that work has been highlighted to states, to scholars, to practitioners across the globe repeatedly. Today is an opportunity to celebrate Shane's work at this inaugural professorial lecture and to learn from him as he continues his excellent, hugely important research and scholarship and to celebrate his achievements. And I'm going to hand you over now to Professor Ray Murphy. Thanks.
So good afternoon, everybody, and you're very welcome. I'm not quite sure what's left for me to say about Shane at this stage, except to say that it's a privilege for me to introduce him in this way. I've known Shane for about 25 years at this stage. He came to Galway, having graduated from Limerick, and one of his former professors here, Patricia, and he took the LLM in International Human Rights Law, was an outstanding student, finished top of his class, and then did his PhD under the supervision of Professor William Shabas. And later went to University of Ulster and came back to us. But Shane, as Siobhan has highlighted, is one of the best colleagues that I've worked with. He epitomises all that is best in academic pursuit. He is an internationally renowned scholar in the fields of international criminal law, international humanitarian law, but also has carved out a particular level of expertise in business and human rights and other human rights related issues. So Shane has an outstanding profile in terms of his publications. Among the things that I really envy that he managed to do, he always used every opportunity to enhance his scholarship and his learning. His times on research leave what we normally call sabbatical, have been in the Central European University in Budapest, in Kyoto in Japan, in the University of Queensland, in Boston at Harvard University's Human Rights Program, and in most instances he managed to be accompanied by his family, which is great. So it's a time for us to recognise the scholarship and collegiality of Shane, the friendship that he's shown to many students and staff over many years, and I am confident that his insights and scholarship will come through in today's lecture. And so I look forward to hearing what Shane has to say. And just to let you know, Shane will speak for about an hour, and then we'll take some short questions. But we discussed this earlier, we do intend to finish as scheduled around 6 o'clock. And then there will be a wine reception at the staff room, which is outside this venue over to the right-hand side, and you're all invited. So Shane, please take the podium.
Thank you, Ray, and thank you, Siobhan, for the very generous comments and the list of accomplishments which wouldn't have happened without the centre itself. But it's a little incomplete. I just want to add, I won a silver medal for singing in the 1990 Feshkio Limni. There was only 2 people in the competition. Actually, I've told that story before about winning a silver medal, but it's not entirely true. There wasn't only 2 people in the singing competition. There was only 1, which was me, but I still only won a silver medal. So I'm not sure, maybe there's a life lesson in there or something. But thanks to Ray and Siobhan for their very generous comments, and thanks to Lisa and Sabrina in the office for their assistance in arranging today's lecture. And thanks, of course, to everyone who is here today. Friends, family, of course, former students, colleagues, and new students also. So I'd like to start with 3 photographs and 3 vignettes. So this first photograph is of City Hall in Dublin, surrounded by barbed wire and British soldiers during the Easter Rising of 1916. The Irish Citizen Army had occupied City Hall, and Kathleen Lynn, who was a medical doctor and an officer in the Citizen Army, was part of that contingent. Now, in her diary of that day, she wrote quite simply, Easter Monday, Revolution. She and a number of other women were captured that week, and they were taken to Ship Street Barracks in Dublin. And in her own words, we were locked up in a filthy store and given blankets thick with lice and fleas. They complained to their guards. They saw some improvement in their condition later in that famous week in Irish history. Now, a few years later, in the Irish Civil War, Lynn would again raise the issue of conditions of detention. Although this time her complaint went outside of Ireland, it went to Geneva. And she wasn't talking about her own conditions, she was talking about the conditions of many thousands of anti-treaty IRA fighters that were held by the Free State authorities. And she took the complaint to Geneva, to the International Committee of the Red Cross. She and a number of other Republican women appealed to the international laws of war as they concerned conditions of detention and prisoners of war. And they sought to have the ICRC, intervene in the conflict in Ireland. The second image I want to talk about is a photograph taken by the French photographer Gilles Perez of Bloody Sunday in January 1972. Now, in the foreground lies the body of Bernard Barney McGuigan, who was shot dead during the Civil Rights March in Derry in January 72. And in the background, you can see a group of marchers. One of them is waving a white handkerchief, seeking shelter. You can see a British Army vehicle, and you can see the body of another person who was killed, one of the 13 killed on that day. Now, aged 41, McGuigan was killed instantly by shots fired by a British Army paratrooper, Lance Corporal F. And as confirmed by the Bloody Sunday inquiry almost 40 years later, McGuigan was posing no risk to anyone. And the claim by Soldier F that he fired on someone who was holding a weapon was in fact false. Now, so the Bloody Sunday inquiry effectively annulled the official line that had been endorsed with the publication of the Widgery report in April of 1972. The Tribunal of Inquiry, chaired by Lord Widgery, had effectively exonerated the soldiers, saying that Many of those that were killed had been handling bombs or firearms during that day. And Edward Heath, who was the British Prime Minister at the time, praised Widgery's objective and painstaking analysis of the events of that day in the House of Commons. Now, the publication of this report was obviously met with great dismay and anger, particularly by the families of those that were killed on Bloody Sunday. But there was an immediate determination not to let this be the final say on what happened on Bloody Sunday. And Bernard McGuigan's wife, Bridget, told an Irish Times reporter in the Bogside, on the very day this Tribunal of Inquiry report was published, that she was going to take a case to the European Court of Human Rights in order to clear her husband's name. The third photo then I want to show is the Al-Shifa Hospital in Gaza, one of the many hospitals in Gaza that has been the scene of tremendous suffering and loss of life as Israel systematically attacks the health system. It's just one facet of the intentional assault on the very conditions of life in Gaza. No hospital in Gaza has been fully functional for many months now. An explosion at another hospital, the Al Ahli Hospital in mid-October, saw dozens of Palestinians killed, and a statement was issued by Micheál Martin, the Irish Minister for Foreign Affairs, condemning this particular attack. Now, there was some controversy over the source of the attack. The health ministry in Gaza said it was carried out by Israel, while Israeli authorities said it was caused by a misfiring Islamic Jihad rocket. But Micheál Martin, in his statement, as well as in an interview that he gave on RTE Radio, said, "There is a role in this circumstance for the International Criminal Court to determine what it is that happened, whether a war crime has been committed." And he was one of the first foreign ministers to invoke the ICC's role in the context of Gaza. Now, each of these snapshots illustrate what I'd like to discuss in today's lecture, which is the who, what, when, and why of appeals to international law and institutions during times of conflict in Ireland, as well as in conflicts elsewhere in which Ireland has taken a considerable interest, specifically Palestine. And over the course of the hour, I will focus on three instances. The period in Ireland from 1916 to 1923, incorporating the Easter Rising of 1916, the War of Independence from 1919 to 1921, as well as the Civil War, which spanned across 1922 and 1923. I'll also discuss Bloody Sunday in 1972 and the early years of the 30-year Troubles in the North, as well as the continuing atrocities in Gaza, the latest and perhaps darkest episode that we've seen in the Middle East. Now, each are, of course, significantly different with varying political and indeed legal contexts, but the common thread running throughout is that Irish political and legal actors, as well as civil society and victims, have for over a century invoked international law in the face of continuing human rights abuses and atrocities. And such appeals, I hope to show, have had various underlying motivations: humanitarian, justice and accountability, condemnation, internationalization, and external validation, while also encountering some obstacles and downsides. So let's begin. So this is the first sitting of the Dáil in January 1919 in the Mansion House in Dublin. And at this first meeting, a provisional constitution was adopted, a declaration of independence was made, and a message to the free nations of the world was issued. The message was read first as Gaeilge, then in French, and then thirdly in English. And it called on every nation, every free nation, I should say, to support the Irish Republic by recognising Ireland's national status and her right to its vindication at the Paris Peace Conference, which was going to take place following the First World War. Ireland, the message stated, reasserts her historic nationhood the more confidently before the new world emerging from the war, because she believes in freedom and justice as the fundamental principles of international law. Permanent peace in Europe, the message stated, can never be secured by perpetuating military dominion for the profit of empire. At the dawn of the promised era of self-determination and liberty, Ireland will suffer foreign dominion no longer. Now, the language of the 1919 message to the free nations of the world as it concerns international law is echoed in our 1937 Constitution and can be found in Irish foreign policy in the intervening century. But claims to international law were made before the Irish state came into existence and before the Dáil first sat in 1919. The laws of war, what we would term today international humanitarian law, were a frequent, if understudied, feature of the period of conflict from 1916 to 1923. So during the Easter Rising, the week-long fighting of a very significant part of Irish history, Thomas MacDonagh, who was one of the signatories of the proclamation of the Irish Republic, claimed that if the rebels can continue fighting for 3 days, being a uniformed force, we may be able to invoke the terms of the Geneva Convention. Pádraig Pearse, who was perhaps the most well-known of the leaders of the Easter Rising, told his fellow volunteers in the GPO, the General Post Office, pictured here a few days after the fighting, he said, "We have now successfully held out as a republic against the might of England for 3 full days." They both had an obsession with 3 days, and I'm not sure where they found that in terms of international law. But they said, according to international law, we are legally entitled to the status of republicanists and the presence of a delegate at the peace conference that will follow the war. Now, these rebel leaders, who were executed less than a week later, made these appeals to international law to legitimise their actions, to demonstrate that they were a state in waiting and with the view to be treated as regular soldiers. Some of those against whom they were fighting were even persuaded by these arguments. One British Army captain who had been captured by the rebels in the Easter Rising later said, "I was impressed by the international tone adopted by the Sinn Féin officers. They were not out for massacre, for loot, or for burning. They were out for war, observing all the rules of warfare and fighting clean." However, the laws of war were also invoked to justify the suppression of the rebellion. A captured group of Irish volunteers were told by another British Army officer, "You all know the rules of war where rebels are concerned. They are shot without trial." Now, the leaders of the Rising were indeed executed after cursory court-martialed, and hundreds of those that were captured were taken to England and Wales and interned. But there was immediate claims made that they were entitled to prisoner of war status. George Bernard Shaw, the playwright, said those that had been executed were shot in cold blood. They were prisoners of war, and it was entirely incorrect to slaughter them. The Irish Times, on the other hand, editorialised that these Irish Confederates of Germany were executed under the laws of war. In 1916, the concept of prisoner of war status only formally applied under international law during a war between recognised states, and not in internal wars or so-called wars of independence. But this did not prevent people from invoking such status, claiming it, or even to an extent being granted it. Cumann na Món would campaign for POW status throughout this period, claiming that it was the right of those prisoners under international law. Thomas Pugh, who had fought during the Easter Rising, recounts an element of confusion on the part of the English authorities when they were indeed taken to England. He said, "We were nobody's children. We were neither prisoners of war nor convicts, and they did not know what to do with us." There was indeed demonstrable confusion on the part of the British authorities at this time. The director of prisoners of war at the War Office wrote within a week of the Rising, "Those who've been captured are not true prisoners of war," yet others in correspondence referred to them as the Irish prisoners of war. One detainee recounted how another official told the rebels, to their surprise, that they were going to be treated as such. "Naturally, we felt highly elated at the news. It was more than we had dared to hope for." The symbolism was clearly very significant. It was a concession that we would never have received had England not been in a pretty tight fix. So hundreds of Irish prisoners were sent to Frongoch camp in Wales, which had been established to hold German prisoners of war during the First World War. They had initially been provided with envelopes and postcards that were stamped with prisoners of war, and no stamp was required to send these letters and these postcards back to Ireland. This gave us considerable satisfaction, one of them wrote in his letter, because of the status, the symbolism of being identified as a prisoner of war. However, the British authorities were neither obliged nor fully committed to granting POW status. These were given, it was said, at the courtesy of the British government, and they could be withdrawn, such as when plain envelopes were issued to the consternation of some of the detainees. Letters that came from Fronguk back to Ireland recount the frequency with which this issue was raised by the detainees with the camp commandants. Michael Collins, who would later become one of the most significant figures of the period, said, "We were specifically told that we are not prisoners of war, but we are afforded some of those privileges." Joseph Malone's letter gives a similar account of what they were told. "You are not prisoners of war. A prisoner of war is a man taken under arms, fighting for his own country against the forces of a foreign state. You have rebelled against the king's government of your own country, so you're not prisoners of war, but through the clemency of the government, you're being allowed certain privileges that are granted to prisoners of war." So this selective approach to granting POW status would also be a feature of the subsequent War of Independence and the Civil War as well, to which I'll return shortly. So during the Easter Rising, the laws of war were also invoked in relation to the ammunition that was used by the Irish volunteers across the few days of fighting. So in this next photograph, we see Molly Childers and Mary Spring Rice on board the Asgard yacht. Molly is holding a rifle, and in front of her is a box of ammunition. You can see it's got Hamburg stamped on it. These two women played their part in the Hoth gun running of 1914 when rifles and ammunition were landed in Ireland. Molly's husband Erskine had travelled to Germany with Darrell Figgis a few months previously to secure the weaponry. And when they realised that the ammunition that they had got was not actually capable of being used in the sense that it was contrary to international law, this did raise some concerns, because an international declaration of 1899 I said that explosive or dum-dum bullets, which they had received, were contrary to international law. And the volunteers were aware of this. Pádraig Pearse, in a letter that he wrote from Rosmuck in Connemara, said the ammunition that has been landed is useless. It consists of explosive bullets which are against the rules of civilized war and which, therefore, we are not serving out to the men. But the bullets did get into the hands of the volunteers. And according to some statements made following this period, there was a recognition on their part that their use was barred by international law. And some of the volunteers sought to taper down the bullets to prevent their explosive character. Another recalls how when they were detained after the rising, a British Army captain roared at them that the British Army are not a herd of elephants. You shouldn't be using those bullets against us. Now, with the Easter Rising being a relatively short affair, it was not the end of the fighting in this particular period that I'm speaking of. British General John Maxwell had said, and he had overseen the controversial and indeed counterproductive executions of the leaders, he had said, another rebellion in Ireland is simply a matter of occasion. He said in the summer of 1916 that there is no respect for law and order in Ireland. And he added, and I'm not sure whether we should take some pride in this or not, he said, there is no people in the world more fond of quoting the law or who are more cunning at evading it. Now, no doubt he would have used the phrase lawfare had it been in existence at that time. Now, conflict did indeed return, and during the War of Independence and the Civil War, there was again legal contestation over issues of POW status, the use of ammunition, resort of reprisals, to mention just a few. The international laws of war were invoked at home and abroad by military figures, politicians, lawyers, activists, and concerned citizens. And this was done to highlight conduct that went against the established rules, to legitimise the actions of those taking up arms against the British state and in turn the Irish Free State, and in an attempt to ensure humane treatment of internees. The IRA during the War of Independence and the anti-treaty IRA during the Civil War often made kind of broad general statements claiming that they adhered to the rules of war, that their opponents did not, and that particular practices were lawful. So Michael Collins, who I mentioned already, during the War of Independence, he said that the IRA, of which he was the Director of Intelligence, conducted the conflict, difficult as it was, with the unequal terms imposed by the enemy, as far as possible according to the laws of war. I have a photograph of him here. It's a slightly irregular photograph. I should maybe explain why I've used this one. My two sons are in attendance today, and 50% of them are interested in history, 100% of them are interested in sport, so I thought I'd throw in a bit of trivia here, which is Michael Collins throwing in the slitter at the Leinster hurling final in 1921 between Dublin and Kilkenny. A prize for anyone who knows who won? Not Kilkenny, Dublin won, which is against the run of play these days. The All-Ireland final was played 2 years later because of the conflict, and Limerick, where I grew up, beat Dublin, I'm pleased to report. So back to Collins. Collins claimed that British soldiers, when they were captured, were treated as POWs. They were treated honourably and considerately and released after they had been disarmed. The English, he said, waged a sort of war but did not respect the laws and usages of war. Liam Lynch, who was the Chief of Staff of the anti-treaty IRA, claimed that despite the terrorist tactics of the Free State, we have honourably stood by the rules of war. We have at all times adhered to these rules. Captured National Army soldiers are accorded all the rights of prisoners of war, treated as fellow countrymen and former comrades. The laws of war were also invoked to justify particular IRA practices, such as the killing of informers. All nations are agreed as to the fate of informers, the IRA proclaimed in 1920. The extreme penalty of death, Dan Breen said, could be paid by informers according to all the recognised rules of war. The British authorities, and in turn those of the Free State, never formally applied the laws of war during the War of Independence or the Civil War. But they did invoke them and appeal to them to condemn the activities of the IRA, while also claiming that they adhered to their essence as it related to the treatment of prisoners that had been captured. On occasions, the laws were entirely dismissed or viewed as a tool to be deployed against the enemy. So during the War of Independence, for example, British Prime Minister David Lloyd George said, "You don't declare war against rebels." And it's fair to say that the laws of war at the time only formally applied between conflicts taking place between states, or war between civilised nations, to use the problematic language of the 1914 British Manual of Military Law. And yet, the laws of war were invoked to condemn IRA attacks. Sir Neville Macready, who was the last general officer commanding of British troops in Ireland, said that every law of civilised warfare has been thrown to the winds by the killing of over a dozen auxiliaries in the Kilmichael ambush in November of 1920. The IRA were using explosive bullets, he said, which are barred by all civilised nations. Now, in his famous "We Have Murder by the Throat" speech, Lloyd George said in November 1920 that those who carry explosive bullets are dealt with summarily in war. If it is war, the rules of war must apply. The IRA, he said, who claim they are fighting a war, cannot complain if we apply some of the rules of war. Now, during the Civil War, the Free State authorities were aware of, but mostly dismissive of, the laws of war. George Gavin Duffy, who was the Minister for External Affairs, had recognised that such laws were not intended for civil war, but actually he had sought to have them applied. Kevin O'Higgins, who was Minister of Justice, was having none of it. He said there are no real rules of war, for war is anarchy, and there are no rules and no laws to guide men. Nevertheless, as the British had done, the laws were invoked to condemn the anti-treaty IRA activities, such as use of explosive bullets, which was described as a war crime, as well as abusing the symbols of the Red Cross or the white flag, which they said amounted to heinous offences against humanity, language quite similar to the concept of crimes against humanity that we would use today. Now, it's in relation to the status of prisoners of war that we again see a concerted effort to appeal to the laws of war and have it applied at this time, as well as denials of its complete application. At a relatively late stage in the Irish War of Independence, the British Judge Advocate General Felix Cassell wrote in a legal memo that it cannot be too clearly emphasised that Sinn Féiners are not in any sense belligerents carrying on hostilities in accordance with the laws and usages of war. They are merely a gang of murderers and assassins. By their foul and illegitimate modes of warfare, they have rendered themselves liable to the death penalty by the laws and customs of war. Now, Neville Macready, who I mentioned already, issued a pamphlet telling the IRA that they did not satisfy the criteria of the Hague Regulations. And that's the image there on the left, where he reprints the 4 criteria from the Hague Regulations of having a fixed command, wearing a distinctive emblem, carrying your arms openly, obeying the laws and customs of war. The IRA, in their official organ, said we comply with all the requirements of the Hague Regulations. Now, despite the formal rejection of POW status, those that had been detained during the War of Independence were given status similar to that would be given to POWs. And this is how Hammer Greenwood addressed it to the House of Commons in 1920. He said, "We do this in a way that it's similar but not quite, and it does not in any way imply the recognition of these men as prisoners of war or the grant to them of that status." And as negotiations were underway between the British and Irish in terms of ending the War of Independence, the British authorities were giving serious consideration to recognising the belligerent status of the IRA for fears of a renewal of conflict. And this was set out in a secret memo of October 1921, saying that if they did comply with these criteria, they would be given belligerent status, even though it was not an international armed conflict. The stance was not humanitarian. It was motivated by military considerations, and it was one of a range of proposed measures that would allow for easier identification of the enemy and the use of internment rather than what were seen as being complicated trials. The official British Army record of the rebellion claims that confidential orders were indeed issued at this time, saying any members of the IRA that were wearing uniforms would not be subject to court-martial and would instead be interned. Now, during the Civil War, which itself arose over disagreements of the content of the treaty which ended the War of Independence, the anti-treaty IRA claimed that the designation of prisoner of war status was our rightful status. IRA prisoners should have separate and distinct conditions from other prisoners that were held at this time. Now, the similarity between the Civil War and the War of Independence concerning this issue is quite apparent. Hannah Sheehy Skeffington put it, their demands today are exactly the same. And it was not only the IRA that made this claim, but civil society organisations both within Ireland and beyond also invoked POW status for the anti-treaty IRA. There was 2 American commissions, one on Irish independence and another on conditions in Ireland, which condemned Britain for violating the laws and customs of war. The former had pushed the case at the Paris Peace Conference in 1919 for Ireland's independence, albeit without success. And sometimes we see the invocation of the laws of war went hand in hand with claims for independence and self-determination. Now, a significant difference during the Irish Civil War to these claims that were being made was that we had seen the first steps being made towards an international standard concerning the treatment of prisoners during times of civil war. Those of you that will go on to study international humanitarian law will see quite evidently that the law covering non-international armed conflicts has been slow to catch up with international armed conflicts and the law applicable to it. In the context of prisoner of war, I'm not sure that it has ever fully caught up. But just before the end of the War of Independence, at the 10th International Conference of the Red Cross, they adopted a resolution saying that political prisoners in times of civil war should be treated in accordance with the principles which inspired the drafters of the Hague Regulations. So a very first tentative step in this direction. And it's this particular standard that played a role when Kathleen Lynn went to Geneva and when George Gavin Duffy invoked it in debates during the Irish Civil War. Gavin Duffy, who was perhaps the most prominent lawyer of the period, having represented Roger Casement in his treason trial and been a reluctant signatory of the treaty, invoked the resolution that was adopted in 1921. And his papers, when he served as Minister for External Affairs, show that he had contemplated granting POW status to the anti-treaty IRA for the time being, and so far as circumstances shall permit, to use the language from the excerpted papers. He also invoked a resolution during debates within the Dáil, saying this would provide political, legal and various other propaganda reasons to support taking such a step. His colleagues weren't overly impressed. One said he had become a thorn in our side with his finicky legal attitude. General Richard Mulcahy, who was the Commander-in-Chief of the National Army and Minister of Defence, rejected Gavin Duffy's argument, saying, "I'm not prepared to throw the grand high cloak of prisoner of war over the irregulars." In other words, it was seen as being some sort of legitimation. In practice, as Cahir Davitt, who served as the National Army's first Judge Advocate General, said, IRA members during the Civil War were granted de facto belligerent status for the first few months of the Civil War. Mulcahy took his own particular stance, he said, because he did not want to exclude the possibility of drastic punishment, meaning execution. Now, during the Civil War, several dozen anti-treaty IRA were executed, some extrajudicially, some in reprisal, and others following a trial. The most prominent of which was that of Erskine Childers, husband of Molly, who had played a role in the Howth gun running of 1914. He had been charged with possession of a revolver. This revolver, which was said to have been given to him as a present by Michael Collins, who was, of course, was on the pro-treaty side during the Civil War, but had already been killed at this time. Now, Erskine Childers' lawyers invoked the Red Cross resolution at his trial in 1921, saying this is the document that has received international recognition, and it is laid down therein that in civil wars, political prisoners are entitled to be treated as prisoners of war. The judge wasn't persuaded. He said, a state of war does exist in Ireland, and it has displaced the civil courts, but force is now the only remedy, and those with such responsibility must be the sole judges as to how it should be exercised. So following Childers' death sentence, Kathleen Lynn's diary read, "Please God, the International Red Cross will intervene." But there was no intervention at that time, and Childers was executed by firing squad in November of 1922. This was, he wrote in his final letter to Molly, a soldier's death, like lying down at the end of a long day's work. His solicitors dutifully returned the copy of the Red Cross resolution to his widow, Molly, afterwards. So these Civil War executions, as well as conditions of detention and allegations of torture, are what prompted a number of individuals, including Kathleen Lynn, to contact the International Committee of the Red Cross in Geneva. Kathleen Lynn was one of several Irish women who had travelled to Geneva specifically for that purpose. Their claims were treated quite sceptically at times. The ICRC president himself said, "We need to be cautious here. These might be the exaggerated accounts of a few ladies with sensitive hearts." Eamon de Valera, who was president of the anti-treaty Republican government, expressed his frustration at these efforts, saying, "They are constantly being made without any clear idea as to what precisely is to be done." He wrote to Kathleen Lynn, criticising her belief in the false promises of the Red Cross. Nevertheless, after he had taken legal advice, and despite being warned that such a complaint will expose us to the meanness and cruelty of our own people, a detailed and documented complaint was submitted to the International Committee of the Red Cross in January of 1923. The Free State authorities, for their part, did not recognise any right on the part of the ICRC to meddle in Irish domestic issues, although they did allow a delegation to visit in April 1923 as an act of courtesy. The visit was carefully managed. The delegates visited just a few camps, and they weren't allowed to speak or meet with those who had been detained. Even so, the formal report which they produced, and which the Free State authorities had seen in advance and had been told it would be favourable, concluded that the conditions in the camps correspond with the normal treatment of prisoners of war in conformity with the principles which inspired the Convention of Geneva. Kathleen Lynn's diary records her frustration. Red Cross reports favourably on camps. They never came near any of us who asked for commission or heard our side. Strange equity. And the Free State authorities instantly harnessed the report for propaganda purposes, claiming that it found that any allegations that had been made were entirely unfounded, that the prisoners actually received full prisoner of war treatment, that the original complaints were part of a policy deliberately intended to discredit the government. So the ICRC's intervention in Ireland in 1923, one of the first times that the organisation intervened in a civil war, did little to alleviate the conditions of those detained, and it has been claimed may have made matters worse. Efforts to have what was described as a worthless report revised subsequently were unsuccessful. So looking back a century later, frustration is palpable in the face of evident breaches of the laws of war. And the laws of war were in the public consciousness at that time. They were at the forefront of the thinking of military and political leaders, as well as civil society and the general public. And with killings, property destruction and detentions taking place, clearly on a much lower scale than what was happening in continental Europe, there was a certain inevitability that claims to these standards would be made. Now, such appeals may have at times been misguided, may have been prone to error. The laws of war, for example, were not generally considered applicable to colonial wars or civil wars at this time, and more than once protagonists confused the Hague and Geneva Conventions. Even the ICRC in their report referred to the Convention of Geneva when it should have been the Convention of The Hague. Claims that they complied with the laws of war were not always borne out, that particular practices were lawful was not always evident. And the appeal to the laws of war was double-edged. The law could indeed offer a standard of humanitarian protection, but it's not one that was automatically guaranteed, and it could be a potential victim of politics, as the visit of the ICRC was. The IRA, the Irish Volunteers, they invoked the laws of war largely to emphasise their legitimacy. Joseph Lawless wrote that POW status was very important to how we as a body ranked in the public opinion of the world. But they had to contend with those same laws being applied to deny certain entitlements, to serve as a tool of the British authorities in suppressing the rebellion, as well as for international institutions being potentially manipulated. So the period from 1916 to 1923 can therefore be seen as a cautionary tale on the promise of international law during times of conflict. So I'll pass over the Second World War, during which Ireland was neutral and sought to adhere to the law on neutrality. And I'll turn to Bloody Sunday, which happened at a time when serious conflict had returned to the island after almost 50 years. So during the Troubles, international humanitarian law, as the laws of war had become known, was not formally applied. Even though Ministry of Defence lawyers had conceded at times that the conditions for a non-international armed conflict had been met, and POW status was claimed also at times by members of the Provisional IRA. But international human rights law was applicable. The United Kingdom was the first state to sign and ratify the European Convention on Human Rights. When Bridget McGuigan referred to the European Court of Human Rights back in April of 1972, it was something of a novelty to do so, compared to the frequency with which the Strasbourg Court is invoked today. Now, even before that time, there had been efforts to draw international attention to the conflict in Northern Ireland and to make comparisons with other situations around the world. The civil rights movement in the North, of which the former dean of our law school here, Professor Kevin Boyle, founder of what was then called the Irish Centre for the Study of Human Rights, he played a central role in that, and they drew inspiration from civil rights actions in the United States in particular. And internationalisation took the form of calling on outside actors to act as impartial observers whose objectivity might validate the experience of victims. So the ICRC again visited a number of prisons in the 1980s, while the Bloody Sunday inquiry itself, although chaired by a British judge, Lord Saville, had 2 other members from outside of the jurisdiction, which was the first in the long history of inquiries in the United Kingdom. Now, in terms of appealing to international law, by the time of Bloody Sunday in January 1972, Ireland was already taking the United Kingdom to the European Court of Human Rights in Strasbourg due to its use of internment and torture, as well as a number of killings by British state forces in Northern Ireland. Sean MacBride, who had been detained as a member of the IRA in the 1920s, and whose mother, Maud Gon MacBride, had campaigned for prisoners' rights throughout that period, he wrote as the chair of Amnesty International to the then Taoiseach Jack Lynch, saying, "An application to Strasbourg could have an immediate effect on the behaviour of British forces in the 6 counties." And following Bloody Sunday, the Irish government sought to amend its existing application to the Strasbourg authorities, arguing that the shooting of civilians clearly amounted to violations of the right to life as protected by Article 2 of the European Convention. The UK was relying on the findings of the Widgery Tribunal, which Ireland said at that time are in total conflict with the evidence we have shown in Strasbourg. Now, the European Commission ultimately found that this additional application was inadmissible, meaning it wasn't going to go any further. Ireland, they said, had failed to bring substantial evidence of the existence of an administrative practice involving official tolerance and repetition of acts causing deprivation of life. The Commission would not deal with these deaths until it were shown that the domestic remedies had been exhausted. Ireland had argued that the absence of prosecutions of British soldiers, a recurring and enduring feature of the conflict, constituted official tolerance and acceptance by the UK. Now, Ireland could have perhaps strengthened its application by including other examples of the dozens who had been killed at the hands of state forces prior to Bloody Sunday, but the Commission had set a very high bar which Ireland was unable to satisfy. The rest of the application, the Ireland versus United Kingdom case, proceeded, and the Grand Chamber only mentioned Bloody Sunday in passing, stating that it did lead to a new upsurge in IRA support amongst the Catholic community. The judgment in Ireland versus UK also failed to treat the 5 interrogation techniques that were used as amounting to torture, describing them instead as inhuman and degrading treatment. And this decision has cast a long shadow in international human rights law, having been deployed in the notorious torture memos that were written after the appalling events which took place on this day 23 years ago in the United States. As a little personal aside, I was in New York with Anne-Marie that summer. I left 2 days before 9/11 to fly back to start my studies here at the Irish Centre for Human Rights. And I remember being at a payphone in the Students' Union trying to phone herself and not being able to get through on that day, but everything was fine in the end. So in terms then of Ireland engaging with the European Court of Human Rights, Ireland has subsequently sought to have that Ireland versus UK judgment reviewed, in part because of the discovery of new evidence, including the famous Rees torture memo that I've put up there, but they were unsuccessful in that regard. But with regard to Bloody Sunday itself, the families sought to go to the court themselves in the 1990s. So the previous effort was by the Irish state. In this instance, they sought to go themselves. The court, by this time, had a number of other cases on its docket, while violations had also been brought to the attention of UN experts, such as the UN Special Rapporteur on summary and arbitrary executions. Strasbourg again failed to accept the complaint, and again for procedural reasons, saying that the complaint was inadmissible as it fell outside the 6-month period following the relevant final decision of the domestic authorities, meaning in this case the Widgery Tribunal, the RUC investigation and the inquests. So with this declaration of inadmissibility in 1996, Strasbourg was effectively closed off as a route of accountability for Bloody Sunday. The families remained undeterred, Pushing at the international level, they spoke about taking a case to the United Nations, as well as at the domestic level, pushing for a new inquiry, I should say. Now, the lack of state accountability before the European Court of Human Rights for Bloody Sunday is confounding, but it was not an anomaly. Throughout most of the conflict, individual applications were few and were only occasionally successful. When the court became more assertive in the 1990s, it did make certain findings against the United Kingdom, but it was described as having a relatively easy ride in Strasbourg over the course of the Troubles. The European Convention, of course, had not been implemented in domestic British law until 1998. The Human Rights Act of that year did not lead to the Bloody Sunday inquiry, but it certainly shaped it. There has been a sustained hostility on the part of the British state in recent years towards the European Convention itself, partly on account of its application in conflict and including outside of the United Kingdom. I'm talking specifically about Iraq. So we've seen threats to withdraw from the European Convention become a staple of conservative politics in Britain. Other efforts have included preventing prosecutions of British soldiers for operating overseas and shutting down investigations in Ireland under the Legacy Act of 2023. Now, the passing of this legislation prompted Ireland to again lodge an interstate application at the European Court of Human Rights against the United Kingdom in January of this year, alleging that giving immunity in this way was contrary to obligations under the European Convention. With the coming into power of a Labour government more recently, the threat of withdrawal from the ECHR has receded, the Legacy Act is set to be repealed, and the interstate application recently made by Ireland may in due course be withdrawn, although Ireland has said we'll take a step-by-step approach to this. So no doubt the Irish and British governments are now more closer in their thinking concerning dealing with the past in Northern Ireland. The same cannot be said, however, in relation to the horrors that have been visited on Gaza over the course of the past almost a year at this point. While Ireland has at times been a voice of reason during a period of seemingly endless atrocities, both current and previous British governments have, to varying degrees, enabled Israel's violence, providing the means, as well as seeking to obstruct efforts to achieve international justice for the atrocities taking place. Now, before turning to Gaza, I want to speak just briefly about Ireland's role at the United Nations Security Council. It's worth mentioning that Ireland has found itself sitting on the UN Security Council as a non-permanent member at times of significant international conflicts. For example, the commencement of the War on Terror following September 11, 2001, as well as the invasion of Ukraine by Russia in February of 2022. Ireland has again, during this period of these two periods, appealed to international law. So Ireland supported US efforts after the 9/11 attacks, including the military campaign launched in October 2001 in Afghanistan against Al-Qaeda and the Taliban. Taoiseach Brian Cowan at that time called for it to be in as short a time frame as possible, civilian casualties to be avoided, and for all sides involved in the conflict to respect human rights and international conventions concerning the conduct of war. As to the invasion of Iraq in 2003, Ireland did not explicitly condemn this as a war of aggression, but merely expressed regret that the coalition had acted without explicit UN Security Council authorization. But at the same time, all parties were called upon to abide by international humanitarian law, in particular the Geneva Convention. And this perfectly reflects one of the critiques of international humanitarian law, that it seeks humane war rather than an end to war itself. James Connolly, who was one of the leaders of the Easter Rising in 1916, later executed, wrote in 1915 that there are no humane methods of warfare. There is no such thing as civilized warfare. All warfare is barbaric. So Ireland may have urged the US to fight a humane war in Iraq, but the government also chose to maintain, against considerable public opposition, what it termed the long-standing arrangements for the overflight and landing in Ireland of US military and civilian aircraft. The Irish government was not as reticent regarding Russia's invasion of Ukraine in February 22, rightly voting in favour of the UN resolution condemning Russia for an act of aggression, also observing respect for IHL during the conflict, and joining over 40 other states in referring the situation to the International Criminal Court. So turning to Palestine, which some of our students have spoken about quite eloquently earlier today, Ramez and Hassan and Rania, for the students that were here. The latest cataclysm in Gaza has seen the Irish government and the public in Ireland raise their voices loudly, repeatedly calling for a ceasefire, protection of civilians, unhindered access for aid, release of hostages, and accountability for the crimes taking place. And international law has been a constant in these calls. Within days of Israel's brutal response to the 7th of October attacks and atrocities, there have been many calls for the International Criminal Court to step up, to advance its Palestine investigation, to issue arrest warrants. The potential role of the International Court of Justice was also invoked, given the characterization by some, even then, that Israel's disproportionate, indiscriminate, and vengeful attacks were genocidal in nature. And Ireland has invoked both of these tribunals and has engaged with both on the question of Palestine. So taking the International Criminal Court, Micheál Martin, the Minister for Foreign Affairs, specifically pointed to the role of the court in relation to the Al Ahli hospital attack, as mentioned earlier. The court, he stated last November, is the cornerstone of the system of international justice. Ireland has reiterated its support and of the ongoing Palestine investigation from the very beginning, perhaps subtly trying to send a message to the prosecutor who at the early stages had done very little publicly and had not sought arrest warrants, despite, as Hassan mentioned earlier, Palestine being on the docket of the ICC since 2009. Now, Micheál Martin over the past months has announced increased funding for the court, met with the prosecutor and condemned threats against the court from Israel and the United States, saying its role in ending impunity is essential. Other states, including South Africa and Bangladesh, have decided to refer the situation in Gaza to the International Criminal Court, which, given that an investigation was already open, is perhaps of more political than legal significance. Now, Ireland did not join in this referral despite some calls to do so, given that it had done so in the case of Ukraine, which, as I mentioned, over 40 states had done. Now, while there may have been technical reasons on Ireland's side why it was not necessary to join in the referral, the broader double standards of international criminal justice are abundantly evident in this context. Now, notwithstanding, Karim Khan has indeed sought arrest warrants regarding Gaza. They've yet to be issued. And at least 2 of the 3 Palestinians for which those warrants have been sought seem to have been killed by Israel. Ireland has continued to support the court, including most recently by counting British efforts to delay or even prevent any issuance of arrest warrants. In written comments submitted to the court in last month to the pre-trial chamber, Declan Smith, the legal advisor at the Department of Foreign Affairs, restated Ireland's long-standing commitment to the court and argued persuasively that the Oslo Accords are not a barrier to the court exercising jurisdiction over Israeli nationals. Ireland is to be commended, I would say, for playing its part in defending the court against continuing attacks. The other international court that sits in The Hague, the International Court of Justice, which primarily hears cases between states, has also been confronted by the situation in Gaza and in Palestine more broadly in a number of proceedings. Most notably, South Africa has taken a case against Israel under the 1948 Genocide Convention, while the General Assembly of the United Nations asked the court to issue an advisory opinion on the legal consequences of Israel's prolonged occupation of Palestinian territory. Ireland's Attorney General, Rossa Fanning, argued before the ICJ in the advisory opinion hearings that Israel's presence in the occupied Palestinian territories is unlawful, primarily given that it involves large large amounts of prohibited annexation of territory. The court did indeed find in July that Israel's presence is unlawful and that it should be brought to an end as rapidly as possible. Now, as to the genocide case that South Africa is taking against Israel, the most powerful intervention came not from the Irish state, but from Blinna ní Grálaigh, the Irish lawyer who was a member of the South African legal team. Gaza, she said, is the first genocide in history where its victims are broadcasting their own destruction in real time in the desperate, so far vain hope that the world might do something. The very reputation of international law, she said, its ability and willingness to bind and to protect all persons equally hangs in the balance. Now, when provisional measures were indicated in January, Micheál Martin welcomed them. These are final, these are binding. He said the court is the cornerstone of the rules-based international order. Now, in March, we had an announcement that Ireland is going to intervene in the South Africa versus Israel case. It is worth noting, though, that Ireland has not characterised what's been happening in Gaza as genocide, saying more than once that that's a matter for the court to deal with. Interestingly, the announcement came 2 days after the UN Special Rapporteur on Palestine, Francesca Albanese, speaking here in Galway, described Ireland's outspoken stance as shameful, given that it is not being matched by meaningful measures. Micheál Martin, the Minister for Foreign Affairs, took great umbrage at this in a private letter sent to the rapporteur, and 2 days later we get this announcement. So maybe her words had spurred on the intervention. Now, in the face of the utter destruction and despair that we see in Gaza, it is no longer sufficient, as De Valera suggested almost a century ago, to go ahead, make your public protest and publicise it. While symbolism certainly matters, Ireland has at times put too much stock, I would say, in condemnation of atrocities and in occasional grand gestures. The recognition of the state of Palestine is no doubt an important political development, but to Palestinian victims, it may seem of inadequate consequence. There is a need to move beyond symbolism, to take concrete and impactful measures, to put a real price on atrocity. Bad faith actors can and have ignored accusations that they're violating international law, and at times can deploy those same laws for their own ends. But they cannot avoid the financial or political impact of sanctions if applied effectively. Now, Ireland has called for a review of the EU-Israel Association Agreement, which is welcome. But as the EU seems unlikely to impose sanctions on Israel, then Ireland needs to pursue its own course with like-minded states who stand against unlawful occupation, apartheid, and genocide. We have seen in the past few weeks some efforts to restrict Israeli companies from benefiting from government defence contracts, and the Irish Attorney General has been asked by the Taoiseach to provide legal advice on trade sanctions. Both have come after it was revealed that arms shipments to Israel have passed through Irish airspace. Ireland is at times overly reactive in this space. It has taken almost a year to get to the point of leaders seriously discussing sanctions. With tens of thousands of lives lost and shattered and the gamut of international crimes persisting, Ireland, like all states, needs to ask itself if emphasising the condemnation of breaches of international law by Israel, which has been a recurring mantra for decades, is sufficient to meet their obligations to ensure respect for international humanitarian law. More pertinently, they need to consider if any trade with Israel, not just in goods or services connected with the settlements, may amount to rendering aid or assistance to the unlawful presence of Israel in the occupied Palestinian territories as recognised by the International Court of Justice. If a clear line cannot be drawn between legitimate trade and contributing to such an unlawful situation, then the cessation of trade links would seem unavoidable. That the Irish government should pass the Occupied Territories Bill should no longer even be a subject of debate. So to conclude, which means to finish, Oisín. You'll be glad to hear. A review of a century of conflict-related appeals to international law by Ireland to the world reveals that the invocation of international law is frequent, comes from various quarters, is made to differing audiences, and serves a variety of purposes. From the perspective of compliance and accountability, appeals are often insufficient in and of themselves. There is regrettably no automatic observance of international law, and its enforcement, particularly when it comes to human rights and the protection of victims of war, is often itself a victim of politics and the interests of more powerful states. Victims are often neglected. Procedural rules which may serve the efficiency of an international institution may at times leave those victims facing injustice, and double standards abound. It is said that international law itself is currently on trial. My sense is that it has always been on trial, especially as it relates to human rights and the protection of victims of war. Civil society organisations have always and continue to advocate respect for international law here in Ireland and elsewhere, but they can only take matters so far. It is states, both large and small, that bear the ultimate responsibility for ensuring its observance. And it is the most powerful that deserve the most scrutiny in this regard. For any state, Ireland included, rhetoric must go hand in hand with action. It is not only words, but deeds that are needed to ensure that freedom and justice, the fundamental principles of international law that were central to the 1919 message to the free nations of the world, to make sure that those are realised. I thank you for your attention and look forward to any questions you may have.
Okay, just the finally falls on me to thank Shane for a wonderful presentation, a tour de force of Irish history and international law. And I think he really brought out how we cannot understand the situation in Palestine today without understanding the history. We can't understand Ukraine without understanding the history. And it was really good that the talk gave such a breadth of Irish history and yet provided great insights into our role and where we are today, and indeed the clarion call to do more, because we have that responsibility as a state. We have a history that makes us more empathetic than many other populations. And if the government was to follow the great majority of the people, we would be taking more action, we would be doing more. So Shane, it was a wonderful presentation, and on behalf of everybody here, thank you very much, and it was worth waiting for.